In this episode, we will be discussing Alaska Rental Agreement Prohibited Provisions. The Alaska Uniform Residential Landlord and Tenant Act prohibits a landlord or tenant from using the following provisions in a rental agreement. Foregoing rights and remedies. A rental agreement may not provide that the tenant or landlord agrees to waive or to forego rights or remedies under this act, authorizes a person to confess judgment on a claim arising out of the rental agreement, agrees to the exculpation or limitation of any liability of the landlord or tenant arising under the law, or to indemnify the landlord or tenant for that liability or the costs connected with it, or agrees to pay the landlord's attorney fees. Mobile home parks. A rental agreement between a mobile home park operator and a mobile home park tenant may not deny a tenant of a mobile home park the right to sell the tenant's mobile home within the park, or require the resident or tenant to remove the mobile home from the park solely on the basis of the sale of the mobile home, nor may the mobile home park operator make a rule or regulation to the same effect, except that, within 30 days of written notice by the tenant of intent to sell the mobile home to a specified buyer, the operator or owner of the mobile home park may refuse to allow a sale for the following reasons. The mobile home is in violation of laws or ordinances relating to health, safety, or welfare. The proposed buyer refuses to assume the same terms as are in the existing rental agreement, or the proposed buyer does not have sufficient financial responsibility. Mobile home park improvements. Rental agreement provisions may not require a tenant to provide permanent improvements that become a part of the real property of the mobile home park owner or operator as a condition of tenancy in the mobile home park. However, the rental agreement may require the tenant to maintain existing conditions in the park. Mobile home park required vendor fees. Rental agreements may not require payment of any type of vendor or transfer fee, either by a tenant in the mobile home park desiring to sell the mobile home to another party, or by any party desiring to purchase a mobile home from a tenant as a condition of tenancy. However, this does not prevent the application of normal park standards in charging reasonable fees for services actually performed if the tenant is notified in writing before the agreement. Mobile home park entry or transfer fee. Rental agreements may also not require the prospective tenant to pay a fee to enter the mobile home park, or a tenant to pay a fee to transfer the tenant's mobile home to another location outside the park. However, this paragraph does not prevent the owner or operator from charging a reasonable fee for services actually performed, and if the tenant is notified in writing of the amount of those charges before agreeing to move into the park. Prohibited provisions are unenforceable. Any provision prohibited in this section of laws that has been included in a rental agreement is unenforceable. If a landlord or tenant willfully uses a rental agreement containing provisions known by the person to be prohibited, the other party may recover the amount of actual damages. For additional laws and articles, visit AmericanLandlord.com.